loan debt, which is hitting beneficiaries in ways you might not expect.
Yeah, it's often quite devastating, actually.
Yeah.
And on top of all that, major benefit changes are rolling out literally as we speak.
It's really a convergence of forces, isn't it? Legal, financial, policy,
Yeah.
all intersecting.
Mm-hmm.
And touching on fundamental things like privacy rights, financial well-being, government efficiency.
These aren't just abstract issues either. They have real, tangible consequences for people's day-to-day lives, their income.
Exactly. People rely on this to live.
And that's precisely why we wanted to unpack all of this today. We've got a stack of recent sources, articles, research, court docs. Our mission here is to cut through that, filter out the noise, and give you a clearer picture of what's happening.
We want to pull out the key insights.
Definitely. Just to be crystal clear up front, we're not here to give financial advice.
No, not at all.
Our goal is just to help you get well informed on these complex, important developments that could affect you or someone you know.
Think of us as guides sifting through this with you. We'll connect the dots and help understand the real implications.
Right, let's get into it. First up, this major legal development, it went all the way to the Supreme Court and hits right at the heart of data privacy at the Social Security Administration.
Yeah, this is the case. Social Security Administration v. AFSCME, that's the union, Supreme Court number 24A1063.
Oh.
And the court just issued a really critical decision on June 6, 2025. It stirred up a lot of debate.
And this all started with an executive action earlier in the year, didn't it?
It did. It traces back to Executive Order 1400 NT8, signed back on January 20th, 2025.
And that order created, well, it created a new department.
Yes, the memorable Department of Government Efficiency, DOGE.
DOGE. Okay, aside from the name, what was its stated goal?
The idea was to modernize federal technology and software, aiming to maximize efficiency and productivity across the government.
Right.
And a key part of the EO was requiring agencies, including the SSA, to set up these internal DOGE teams.
Okay, teams within the agency to find efficiencies.
Exactly. And here's the crucial part. The EO mandated these teams get full and prompt access to all unclassified agency records, software systems, and IT systems.
Look around prompt access. That sounds broad.
Very broad. Now, it did add the phrase consistent with applicable law.
The caveat.
Right, and that's really where the conflict began. How do you square full access with laws specifically designed to protect sensitive data like the data SSA holds?
So who challenged this?
Labor unions representing SSA employees, plus a grassroots advocacy group, filed a lawsuit in Maryland.
And their main argument was?
Their core claim was that giving DOGE personnel this kind of, well, unfettered access violates the Privacy Act of 1974, and also the Administrative Procedure Act, the APA. Basically, they argued this level of access was not consistent with the Privacy Act's rules on data disclosure.
So they're saying, wait a minute, this isn't just about efficiency tools. This is about people's highly personal data, so security numbers, bank info, medical records.
Exactly. Data protected by specific laws.
How did the first court, the district court, rule on that?
On April 17th, 2025, the judge actually agreed with the plaintiffs, at least on a preliminary basis.
Okay.
The court issued what's called a preliminary injunction.
What did that injunction actually do? Did it stop DOGE completely?
No, not completely. It put temporary qualified limitations on DOGE's access to the SSA data. It set conditions.
Conditions. And why did the court feel those limits were necessary?
Well, the judge found the plaintiffs were likely to succeed on their claims, meaning the court thought it was probable the government's plan violated the Privacy Act and APA.
That's a key finding, likelihood of success.
It is. And crucially, the court also found that without this temporary relief, the people whose data was at risk, the plaintiffs' members would suffer irreparable injury.
Irreparable injury. Harm that can't just be fixed later with money.
Exactly. Harm that can't be undone once the data is out there. The court really stressed the sensitivity of SSA data and pointed to SSA's own long-standing strict protocols for protecting it.
Right. SSA has systems for this already.
They do. And what's really striking is what the court said about the government's arguments. The judge kept asking why DOGE needed immediate, unfettered, unprecedented access to non-anonymized data.
Especially given the privacy risks.
Right. And according to the court's findings, the government's answers were imprecise, contradictory, and insufficient.
Ouch. Insufficient.
Yeah. The court even noted the government chose to just stand on the record instead of providing more clarification when asked.
So they didn't really explain the need for this immediate, wide-open access.
The court concluded the government never made clear why the DOGE team requires unbridled access.
So the judge basically said, you haven't justified bypassing existing privacy rules right now.
That's the essence of it.
And the solution the court came up with was pretty tailored.
The injunction itself.
Yeah. It wasn't a total block. It specifically allowed DOG teams access to redacted or anonymized data.
Which addresses efficiency without the privacy risk.
Exactly. It also allowed access for DOGE staff who met SSA's usual requirements: background checks, training, signing sanction agreements.
The standard stuff SSA already does.
Right. Consistent with the Privacy Act.
Yeah.
And it even allowed access to specific non-anonymized data if DOGE provided a written explanation of the specific need for that particular data.
So a justification was required for sensitive data. Yes. And the court made clear this didn't stop SSA's ordinary operations. It was framed as a short-term pause with reasonable conditions while the case proceeded.
Seems like a pretty balanced approach, trying to let DOG work, but within established privacy boundaries.
That's how it appears, a measured interim step. But the government wasn't happy with those conditions.
Okay, so they appealed.
They appealed to the Fourth Circuit Court of Appeals and also asked that court for a stay of the injunction, basically. Lift these conditions while we appeal.
And what did the Fourth Circuit decide?
The Fourth Circuit heard the case en banc. That means all the judges, not just a panel.
Right.
And they voted 9-6 against granting the stay. They kept the district court's conditions in place for the time being.
So 2 federal courts now weren't convinced by the government's argument for immediate unfettered access.
Correct. Some of the Fourth Circuit judges echoed the district court, noting the government's inability to provide a convincing explanation of how it will be tangibly and irreparably harmed if the conditions stayed in place.
Still no clear reason for the urgency or breadth of access.
They suggested, like the lower court, that much of DOGE's work could likely proceed with anonymized data or limited access under SSA's usual rules.
Okay, so after striking out twice, the government takes its request for a stay up to the Supreme Court.
Yes, they filed an application for a stay directly with the Supreme Court.
And the Supreme Court's decision on June 6th.
The court granted the stay.
Okay, let's pause there. What does granting the stay mean in practice right now?
It means the district court's injunction, those conditions and limitations, are paused. They're put on hold. So the Social Security Administration can now proceed to give the DOGE team members that broad, unfettered access to records the government wanted all along.
Wow. So the limits are off, for now at least.
For now, yes. The underlying legal case about whether that access is ultimately lawful will continue in the Fourth Circuit and could eventually reach the Supreme Court again on the merits. But the immediate effect of the stay is that the access is permitted.
And the Supreme Court's reasoning, briefly, they just said the factors for a stay warranted it here.
That's essentially what the brief order stated. It mentioned the standard factors: likelihood of success, irreparable harm, balance of equities, public interest, and concluded they warranted granting the stay in this case.
But this is where we get the strong disagreement, right? The dissent.
A very strong dissent from Justice Jackson, joined by Justice Sotomayor. It's highly critical of the majority's decision.
What's their main beef with granting the stay?
The core concern is the timing and the use of the court's emergency powers. The dissent argues the court is allowing SSA to give DOGE potentially unlawful access to the highly sensitive data of millions of Americans right now before any court has fully ruled on whether that access is actually legal under the Privacy Act.
So it's letting the access happen before the litigation is settled.
Exactly. The dissent says the government's only urgency is that it cannot be bothered to wait for the litigation process to play out. Justice Jackson called the court's intervention extraordinary.
And the dissent saw this as part of a pattern.
Yes, it suggested this fits a trend where the court dons its emergency responder gear, potentially intervening too readily in ongoing cases, maybe even fanning the flames, as the dissent put it. It referenced similar concerns from a dissent in an earlier case, Noam v. Doe.
Let's really underline why this data is so sensitive, according to the dissent. Remind us what's at stake.
Oh, the dissent lays it out clearly. Social Security numbers, birth dates, addresses, bank account numbers, very detailed medical records, especially from disability insurance files, work histories.
Basically, your whole life story financially and sometimes medically.
Pretty much. The dissent notes everyone with an SSN is in there, and SSA has been collecting and protecting this since 1935. The Privacy Act of '74 was passed precisely because Congress recognized the potential harm to employment, insurance, credit if this data was misused.
And the act puts strict limits on disclosure.
Yes, it prohibits disclosure except under narrow exceptions, like an employee needing the record for their official duties.
And the dissent argues DOGE's broad access doesn't clearly fit that narrow exception, especially given how SSA usually operates.
Precisely. The dissent highlights SSA's own strict internal rules. Background checks, training, sanctions for misuse, and crucially, limiting employee access to only what they need for their specific job. That's standard practice.
The DOGE wanted different access.
DOGE demanded immediate and unfettered access, which the dissent contrasts sharply with SSA's usual, more cautious approach, especially for reviews aimed at finding fraud or waste. Those typically start high-level, anonymized.
Not the immediate broad access DOGE got with this day.
Right. And a central pillar of the dissent is hammering the point that the government failed in 3 different courts to show why it needed this broad access right now.
Still no convincing proof of immediate, irreparable harm to the government if this stay wasn't granted.
Exactly. The dissent called the government's complaints about the injunction being micromanaging or inefficient, just generalized complaints, basically, griping about having to follow rules designed to protect privacy. Those complaints, the dissent argued, didn't meet the legal bar for showing concrete harm needed for a stay.
So the dissent felt the balance tipped heavily toward protecting privacy while the legal case played out.
Absolutely. Weighing the huge risk to millions of people's sensitive, legally protected information against the government's desire to bypass usual procedures before legality is settled. The dissent clearly felt the risk was too high and the government's justification too weak.
And this leads to that concern about systemic corrosion. What does that mean?
The dissent argues that granting a stay when the government didn't meet the standard requirement of showing irreparable harm sends a troubling message. It suggests the court might be applying different lower standards when the government is the one asking for emergency relief compared to other litigants. This, the dissent fears, could undermine respect for lower court decisions and weaken legal constraints on the executive branch.
So the dissent's view. Lower courts were careful, found the government hadn't justified overriding privacy now, but the Supreme Court used emergency powers anyway, creating grave privacy risks and possibly treating the government's request differently.
That's the core of their argument. They felt the court should have held the government to the established standard for a stay.
Wow. Okay, so stepping back from the legal intricacies, why should you, our listener, care about this court battle over data access?
Because it's your data, your social security number, your address, maybe your bank details, your work history, potentially health information, all held by the SSA. This decision means right now that data is potentially accessible to a new group of government employees under looser conditions than SSA normally requires, while the courts are still figuring out if that's even legal.
It really throws that fundamental tension into sharp relief, doesn't it? Government wanting efficiency, modernization.
Versus the individual's fundamental right to privacy for their most personal information.
And the courts are caught in the middle, trying to balance that. The Supreme Court's stay, for now, prioritizes the government's efficiency goal over the privacy concerns raised by lower courts and the dissenters.
It definitely raises big questions about who gets access, under what rules, and how we weigh efficiency against privacy risk, especially when the need for broad access is contested.
A critical balance indeed. Okay, let's shift gears now, but stick with Social Security. We need to talk about a growing financial problem impacting a specific group of beneficiaries, those also carrying student loan debt.
Yeah, this is a really significant and, frankly, growing issue. People often think of student debt as a young person's problem, but it's been rising dramatically across almost all age groups, including older adults.
That seems surprising on the surface. Why are so many older Americans, people near or in retirement, holding student debt?
It's a mix of things. Some are still paying off their own loans from decades ago. Loan terms can be really long, 20, 30 years sometimes.
Right.
But a huge factor, and one that really pulls at the heartstrings, is older folks taking out parent PLUS loans for their kids or even grandkids.
Ah, so they took on debt to help family get educated.
Exactly. They're shouldering that burden. And the numbers are stark. One source showed the number of people 62 and older with student loans jumped 59% just between 2017 and 2023.
Wow, 59%. How does that compare to younger groups?
For borrowers under 62, the number actually fell slightly by 1% in that same period. So the growth is really concentrated in that older demographic.
And we're not talking small amounts of money here, are we?
Definitely not. Data from a few years back showed average balances around $30,600 for current Social Security beneficiaries 62 plus with loans. It was even higher, over $35,000 for those approaching retirement. And more recent data shows averages like $44,800 for the 60-65 group. Even people in their 80s and 90s, nearly 90,000 of them hold an average of $29,000.
That's a massive weight, especially on a fixed retirement income.
It is, and here's where it gets worse. The double whammy, as one analysis called it. Older borrowers aren't just holding the debt, they're struggling much more with delinquency and default.
So they're falling behind on payments more often.
Yes. Delinquency rates on student loans generally have been high, but older borrowers are twice as likely to be in default compared to younger ones. About 28% for those 62 plus versus 14% for under 62, based on 2023 data.
That's a huge disparity. And the pause on federal loan collections during the pandemic, that's over now.
It is. Forced collections on defaulted federal student loans are back in action. This affects nearly 6 million borrowers overall.
And specifically for older adults on Social Security.
The estimate is that around 452,000 borrowers age 62 and older have defaulted federal loans and receive Social Security. So they are now potentially subject to having their benefits taken.
Okay, how does that actually work? How does the government take money from a Social Security check for student loans?
It's done through benefit withholding, often called an offset. When a federal student loan goes into default, usually after about 425 days without payment and failed attempts to fix it, the Department of Education can use the Treasury Offset Program. This program lets federal agencies collect debts by taking money from other federal payments, including Social Security.
Is there a limit to how much they can take each month?
Yes. There's a rule set by law, the Debt Collection Improvement Act of 1996. They can take the lesser of two amounts. Either 15% of the total monthly benefit or the amount by which the benefit check exceeds $750 per month.
Okay, so they calculate both and take the smaller number.
Correct.
And the number of people facing this and the total money involved has just skyrocketed.
It's truly exponential. The number of beneficiaries having their Social Security offset for student loans went from about 6,200 in 2001
Got relatively small.
to 192,300 in 2019. That's over a 3,000% increase.
3,000%. That's unbelievable. And the dollar amounts.
The total collected annually jumped from around $16 million in 2001 to nearly $430 million in 2019 in today's dollars.
Wow.
For an individual, the average amount taken in 2019 was about $2,232 a year or $186 a month.
Now, $186 might not sound like a fortune, but if you're living mostly on Social Security,
It's devastating. And here's a really crucial and, quite frankly, depressing detail. Data from 2001-2015 showed that almost 3/4 of the money collected through these offsets went towards interest and fees.
wait, seriously, 3/4 didn't even touch the principal debt.
That's what the data suggests. The vast majority was just covering interest and collection fees, not reducing the actual loan.
So the government is taking money from seniors' fixed incomes, and it's barely making a dent in the debt itself.
It certainly raises questions about the effectiveness and fairness of the process. Plus, the Treasury charges its own fee for each offset transaction, like $13 to $15 back in 2016-19.
And the borrower pays that fee.
Often passed on, yes, which further reduces what they get and actually makes the collection process take even longer.
This must cause incredible hardship in the real world.
The reports are heartbreaking. Many beneficiaries with these loans are already financially vulnerable. One source said 37% of them rely on Social Security for 90% or more of their income.
Wow, almost entirely dependent.
Yeah, with average benefits around $1,500 a month for that group, taking nearly $200 out of that is catastrophic.
And it forces terrible choices.
Absolutely. Survey data showed over 90% facing offset reported financial hardship. And this is staggering. Half of those with defaulted loans said they skipped doctor visits or couldn't afford prescriptions because of the cost, tied directly to the offset reducing their income.
Skipping needed medical care. That's just awful.
Yeah, and they reported trouble paying rent, utilities, other essential bills. It's a direct hit to basic needs.
And there's another twist, right? How this affects getting help from other programs.
Yes. This is particularly frustrating. When these beneficiaries apply for things like SNAP food assistance or Medicaid or help with Medicare costs,
Means-tested programs?
Exactly. They often have to report their gross Social Security benefit amount, the amount before the student loan offset is taken out.
Even though they're not actually receiving that full amount?
Correct. So the income used to determine their eligibility for food aid or health care might be artificially inflated, causing them to be denied help they desperately need based on money they never actually see.
That seems fundamentally unfair. It really points to the protections being inadequate, doesn't it?
It strongly suggests that. The main protection is that $750 floor, the minimum amount they can't touch, set back in 1996.
1996. That hasn't been updated for inflation.
Never. Back then, $750 was above the poverty line. Today, in 2024 dollars, it's about $400 below the monthly poverty level for one person. It's almost meaningless as a protection now.
So even if someone's benefit is only slightly above $750, they could still lose 15% and be pushed well below the poverty line.
That's the reality. And even if you did adjust it for inflation, it would be around $450 today.
Yeah.
Many would still face hardship. One analysis looked at the standard used in the SAVE student loan plan, which considers hardship up to 225% of the federal poverty level.
Okay.
Applying that here, 87% of Social Security beneficiaries with student loans fall below that 225% FPL threshold. If they got an automatic hardship exemption like in SAVE, 87% could potentially be protected from offsets.
So a huge gap between the current $750 protection and what a modern hardship standard suggests is needed.
A massive gap. And beyond that flawed threshold, other relief options exist, but they're incredibly hard for people to access.
Like what? What barriers are there?
Well, there's the total and permanent disability TPD discharge for federal loans. It cancels debt for disabled borrowers.
Okay.
And there's been progress. They automated data matching between education and SSA for people disabled before retirement age. That's helped a lot of folks in that group get discharges automatically.
That's good news. But there's a but.
There is. The automation generally doesn't work for people who become disabled after they start receiving retirement benefits or who were already on retirement benefits when they became disabled.
Why not?
Because SSA doesn't systematically track disability status in the same way for retirees. So that info isn't automatically sent to the Department of Education for TPD discharge.
So the burden falls back on the individual retiree to figure it out and apply.
Exactly. They have to know the program exists, be physically and mentally capable of navigating the application, gathering proof. It's a huge hurdle, especially for older adults facing cognitive decline, maybe dementia, which often emerges later in life.
How many people might be affected by that gap?
One estimate suggests over 20%, 1 in 5 of beneficiaries with student loans are retirees who also report a disability. They could potentially qualify, but might be missed by the system.
That's a lot of people potentially falling through the cracks. Any other difficult relief options?
Yes, there's also a specific hardship exemption process for the Social Security offset itself. You can apply to have the offset reduced or stopped based on your income and expenses.
And many people likely qualify based on their finances.
Oh, absolutely. One analysis estimated 82% of beneficiaries with defaulted loans have expenses equal to or exceeding their income. They'd likely qualify for a full suspension if they applied.
82%. So why isn't everyone applying?
The uptake is shockingly low. Less than 10% even applied back in 2015. Reasons seem to be a lack of awareness. People just don't know it exists, including caregivers. And the application process itself can be complex, especially for someone frail or with cognitive issues. And even among those who did apply, approval rates for older borrowers were low, only about 20% back then.
So a process that 8 out of 10 could qualify for, less than 1 out of 10 applies for, and only 1 out of 5 of those get approved. That system is clearly broken.
It certainly appears ineffective at shielding vulnerable people from hardship. And we should briefly mention these issues of debt and delinquency disproportionately affect Black and Hispanic borrowers, reflecting broader systemic inequities.
Right. You mentioned an analysis looking at the potential impact of the Biden administration's proposed debt relief plan on this group. What did it suggest?
That analysis, looking back at 2010-2019 data, estimated the plan could have provided average forgiveness around $12,000 per older borrower.
Okay.
And because it offered extra relief for Pell Grant recipients, Black borrowers were projected to see higher average forgiveness. The impact on actually holding debt was expected to be significant, potentially cutting the share of Black and Hispanic households with student debt roughly in half.
And on delinquency.
Also projected decreases, with Black borrowers seeing the largest absolute drop and Hispanic borrowers the largest relative drop. The takeaway was the plan could have substantially reduced racial disparities and debt burdens among this population.
So while that specific plan didn't fully happen due to legal challenges, the analysis shows what a major policy intervention could potentially do to alleviate this burden.
It paints a picture of potential impact, yes. And bringing this back to you, the listener, even if you don't have student loans, this whole situation highlights how different financial systems collide.
Yes, student debt crashing into Social Security.
Exactly, creating these unexpected severe hardships, especially for vulnerable seniors on fixed incomes. It really raises questions about consumer protection, program effectiveness, and fairness in accessing relief.
A really powerful illustration of interconnected vulnerability. Okay, let's shift now to some really current, broader changes hitting Social Security benefits tied to recent laws and ongoing payment issues.
A huge one is the Social Security Fairness Act, which became law in January 2025.
Right. What's the main thing that ACT does?
It gets rid of two old provisions that used to cut Social Security benefits for certain public workers: the windfall elimination provision, WEP, and the government pension offset, GPO.
Okay, WEP and GPO, who did those affect?
Mainly public employees like some teachers, firefighters, police, federal workers under the old CSRS system, people who earned a pension from a job where they didn't pay Social Security taxes.
And WEP cut their own Social Security benefits from other jobs.
Right, and GPO cut spousal or survivor benefits they might have gotten based on their spouse's record.
And the Fairness Act just eliminates those cuts.
Completely repeals them, so it restores full Social Security benefits for those folks. It's estimated to affect about 3.2 million people altogether, current and future beneficiaries. Around 2.8 million were previously hit by WEP or GPO.
That's a massive number of people getting a benefit change. How's the rollout going? Are people seeing this yet?
Yes, SSA has been working hard on implementation. As of late May, early June 2025, they reported processing about 91% of the affected cases.
And the law included back pay, right? Retroactive benefits.
It did. That was key.
Yeah.
Payments are retroactive back to January 2024. Since December 23 was the last month the old rules applied. SSA started sending out those lump sum back payments on February 25th, 2025.
So most people eligible for back pay should have gotten it by now.
According to SSA's timeline, yes, most should have received that one-time payment by the end of March 2025.
And their regular monthly checks.
Those should have reflected the removal of the WPGP cut starting with the April 2025 payment, which is for the March benefit month.
How much bigger are these checks? Does it vary?
It varies a lot. Depends on their pension amount, their work history, the type of benefit. For some, it's a small adjustment. For others, it could be over $1,000 extra per month, a significant boost.
Okay, so most cases were automatic. But there are still some complex ones needing manual work.
Correct. SSA handled most via automation, but there are around 200,000 to 300,000 cases flagged as more complex, requiring manual review by staff.
What makes a case complex in this context?
Things like the beneficiary passed away recently, so the back pay needs to go to survivors, or maybe there is a previous overpayment that needs sorting out, or someone's applying for benefits for the first time because of the Fairness Act.
What's the ETA for finishing those manual reviews?
SSA says they're prioritizing them and aim to wrap them all up by early November 2025.
Now, has this huge effort, processing millions, sending back pay, adjusting checks, affected other SSA services, wait times, things like that?
Well, SSA officially says no. They state they haven't had disruptions or deferred other important work.
Right.
However, some reports, citing SSA employees, suggest that focusing resources on these complex Fairness Act cases might be slowing down other things, like processing new claims or handling inquiries. So there's maybe a bit of conflicting information there.
Right, official line versus maybe some on-the-ground experiences. So what should listeners do if they think they should have gotten a payment or an increase due to the Fairness Act but haven't seen it yet?
First stop, check your My Social Security account online. That's ssa.gov.uw my account. It has your payment history, benefit details, any notices.
Okay, check online first.
Yes. Or you can call SSA directly at 1-800-772-1213. And definitely make sure they have your current mailing address and bank info. They usually send paper notices explaining changes too.
What about people who never applied before because WIP GPO made it pointless? What's their next step now?
They likely need to file a new application for benefits. They can do that online too, at sao.gov.apply. SSA said they've gotten over 200,000 new applications like this since January and are working through them.
Okay, that brings us to some really recent news reports from early June 2025. Some beneficiaries were apparently missing checks or getting less than expected. What's going on there?
Yes, those reports surfaced, and the reasons cited actually connect back to several things we've discussed.
Was the Fairness Act rollout mentioned?
It was listed as one possible cause for some payment processing delays or glitches impacting a subset of people. Again, SSA disputes widespread disruption, but it was floated as a factor in some reports.
And student loans came up again, too.
They did. Another key reason cited for some people getting lower checks right now is the resumption of those student loan garnishments.
Ah, so people are seeing that 15% deduction hit for the first time or the first time in years.
Exactly. So the student debt offset issue we detailed is actively causing some of these current payment reductions.
Bringing it full circle. What other reasons were mentioned for payment problems?
Other possibilities included SSA recovering past overpayments, which they have to do by law, or changes in medical status for disability recipients, or simple things like banking errors, closed accounts, or eligibility changes, like someone going back to work and not reporting it.
So a mix of potential causes. If someone's check is late or wrong, what's the drill?
SSA generally advises waiting 3 business days past the scheduled payment date first. Things sometimes resolve.
Okay, wait a few days.
Then, if it's still wrong, contact SSA. If you think it's a garnishment, you can also check the Treasury Offset Program website. Just know that disputing a garnishment can take time and paperwork.
Got it. Check online, wait a bit, then call SSA or Treasury if needed. Be proactive.
Definitely.
So, zooming out one last time on the Fairness Act, how big a deal is this law in the grand scheme of Social Security?
It's widely seen as a major change. Some analysts have called it the biggest expansion in decades in terms of restoring benefits to a significant group.
But that expansion costs money.
It does. The estimate is around $200 billion over the next 10 years. And that cost has definitely added fuel to the ongoing debate about the program's long-term financial stability.
And is it encouraging more people to claim benefits now?
It seems to be a factor. One source noted a 15% jump in retirement claims in 2025 compared to 2024.
Wow.
That's partly attributed to the Fairness Act making benefits more attractive for former public employees, but also just the continued wave of baby boomers hitting retirement age.
So bringing this final piece back to you, the listener, whether you're directly impacted by the WEB-GPO repeal or just a current or future beneficiary or even just watching the system, these changes matter.
Absolutely. Understanding these updates helps you know if you might be owed money or see higher benefits. It tells you what to do if your check seems wrong, and it gives crucial context for the bigger conversations about Social Security's future, its costs, and how it adapts.
It's definitely a lot of moving parts. Court cases, debt issues, new laws, payment glitches.
Interconnected parts, though.
Yes, very interconnected. But hopefully, being informed helps you navigate your own situation and understand these powerful forces shaping a program so many rely on.
Couldn't agree more. These developments really show how legal challenges, personal finance struggles like student debt, and big policy changes all weave together.
So just to recap, we dug into that Supreme Court decision on SSA data access and the huge privacy questions it raises. We explored the tough reality of student loan debt hitting Social Security recipients and how relief often falls short. And we covered the major changes from the Social Security Fairness Act and the current payment landscape.
They're definitely not simple issues. They mix law, money, policy, and very personal circumstances. Our goal was just to pull out the key threads for you.
And hopefully you can use this information to stay informed, check your own situation if needed, and follow how these things continue to evolve.
Absolutely. Knowledge is power, especially with something as vital as Social Security.
So as we wrap up, we want to leave you with a final thought to chew on. As our society keeps aging and our financial world keeps shifting, think about widespread student debt across generations, debates on government efficiency versus privacy, long-term funding questions. How might the fundamental purpose of Social Security itself, established almost 100 years ago to protect against poverty and old age and disability, how might that purpose need to adapt? How does it need to evolve to truly meet the very different challenges of today and tomorrow?
That's a deep question. How does a program designed for the 1930s stay truly effective and fair in the 2020s and beyond? Definitely something to think about long after this deep dive ends.
Welcome to Financial Area. I'm Paul.
And I'm Rachel.
Today we're doing a deep dive into something absolutely central to millions of Americans: Social Security.
That's right. It's the bedrock for so many, Paul. retirement, disability.
Exactly. But lately, this program, nearly a century old, it's been navigating some really choppy waters.
Seriously complex stuff. We're seeing legal battles reaching the Supreme Court.
Right, about data privacy, government access.
Then there's the whole issue of student loan debt, which is hitting beneficiaries in ways you might not expect.
Yeah, it's often quite devastating, actually.
Yeah.
And on top of all that, major benefit changes are rolling out literally as we speak.
It's really a convergence of forces, isn't it? Legal, financial, policy, all intersecting. And touching on fundamental things like privacy rights, financial well-being, government efficiency.
These aren't just abstract issues either. They have real, tangible consequences for people's day-to-day lives, their income.
Exactly. People rely on this to live.
And that's precisely why we wanted to unpack all of this today. We've got a stack of recent sources, articles, research, court docs. Our mission here is to cut through that, filter out the noise, and give you a clearer picture of what's happening.
We want to pull out the key insights.
Definitely. Just to be crystal clear up front, we're not here to give financial advice.
No, not at all.
Our goal is just to help you get well informed on these complex, important developments that could affect you or someone you know.
Think of us as guides sifting through this with you. We'll connect the dots and help understand the real implications.
Right, let's get into it. First up, this major legal development, it went all the way to the Supreme Court and hits right at the heart of data privacy at the Social Security Administration.
Yeah, this is the case. Social Security Administration v. AFSCME, that's the union, Supreme Court number 24A1063.
Oh.
And the court just issued a really critical decision on June 6, 2025. It stirred up a lot of debate.
And this all started with an executive action earlier in the year, didn't it?
It did. It traces back to Executive Order 1400 NT8, signed back on January 20th, 2025.
And that order created, it created a new department.
Yes, the memorable Department of Government Efficiency, DOGE.
DOGE. Okay, aside from the name, what was its stated goal?
The idea was to modernize federal technology and software, aiming to maximize efficiency and productivity across the government.
Right.
And a key part of the EO was requiring agencies, including the SSA, to set up these internal DOGE teams.
Okay, teams within the agency to find efficiencies.
Exactly. And here's the crucial part. The EO mandated these teams get full and prompt access to all unclassified agency records, software systems, and IT systems.
Look around prompt access. That sounds broad.
Very broad. Now, it did add the phrase consistent with applicable law.
The caveat.
Right, and that's really where the conflict began. How do you square full access with laws specifically designed to protect sensitive data like the data SSA holds?
So who challenged this?
Labor unions representing SSA employees, plus a grassroots advocacy group, filed a lawsuit in Maryland.
And their main argument was?
Their core claim was that giving DOGE personnel this kind of, unfettered access violates the Privacy Act of 1974, and also the Administrative Procedure Act, the APA. Basically, they argued this level of access was not consistent with the Privacy Act's rules on data disclosure.
So they're saying, wait a minute, this isn't just about efficiency tools. This is